Hi, everybody. Thank you so much for being here today. My name's Jacqueline O'Monier. I'm the Education and Training Officer at Under One Roof. I'm delighted to be here today with Claire Hallibone from the Helensburgh Car Scheme at Argyll and Bute Council. And hopefully today we are going to impart some good knowledge and information your way on all things common repairs and how to deal with the whole process from start to finish, how to get engagement with other owners, what your responsibilities are. So the plan for today is that I'm going to share my screen and we'll go through a PowerPoint presentation. And then once that's finished, I'll come back into the live area with Claire and we will take your questions. This session is being recorded today. You will receive a copy of the recording along with the slide deck and some other information within the next week. So please don't be too frantic about jotting down absolutely everything. As I say, you'll get a copy of everything to look back on in your own time. Please use the Q&A function at the top of the screen whenever I'm talking today during the presentation. If anything comes to mind, something that you want to ask a specific question on, please just put it in that box, and then when we get to the end of the presentation, we'll go through that together, and we'll answer as much as we can today. I think that's probably it from a housekeeping point of view. We are working remotely, so there's no fire alarms or anything like that I need to advise you of that could go off in the background. So what I'll do is just get started, and let me just share my screen. Get this presentation going for you all, and we'll just take it from there. Okay, so if you don't already know about us at Under One Roof, if you've not heard about us before or you're just a bit unsure about who we are, we're Scotland's only charity that provides free, impartial information on repairs, maintenance and retrofit for tenement flat owner-occupiers, landlords and housing professionals throughout Scotland. We're funded by the Scottish Government and 28 out of the 32 local authorities across Scotland, including Argyll and Bute Council, which we're very happy to receive funding from, and that just helps us with the work that we do to work with staff in the local authorities as well as owner occupiers and landlords. Okay, so we always start off with just confirming with our audience what a tenement actually is. Per the Tenement Scotland Act 2004, a tenement is classed as any building that's been split into two or more horizontally for residential accommodation. So that just doesn't mean that we're talking about our traditional blonde and red sandstone tenement properties. We're also talking about properties that are modern flat developments, low-rise and high-rise blocks, converted townhouse villas into flats, or cottage or four in a block flats, depending on how you what your terminology is for that, and flats above shops. So anything where the accommodation has been split horizontally into two or more for residential accommodation is classed as a tenement in Scotland. So we often get people saying to us, "Oh, well, I'm in a converted villa. I've got the attic flat. This doesn't apply to me," when actually it does. We don't obviously cover detached, semi-detached, terraced or townhouse properties, but anything that comes under that definition of a tenement, we can absolutely help you with here. So why is it important to maintain and look after your building? Well, we want you to know what your responsibilities are as an owner. When you bought your property, you didn't just buy your flat, you bought a share of the common areas of the building. So we need you to understand what your responsibilities are there. We want you to be aware of the condition of the building. Nobody wants to have reactive repairs where you're just constantly having unexpected and high bills. So we want you to know what's going on with your building, so that you can be prepared and you understand what your responsibility is for maintenance and what you have to pay for. We want you to have adequate insurance for your building. We've had a few instances recently in Glasgow and in Perth where there's been, in Glasgow, it was a building collapse on the south side. In Perth, it was a fire where unfortunately there was a fatality. And in both of those situations, insurance has been a problem. So it is a legal requirement for owners in tenement buildings to have buildings insurance, and we want you to make sure that you've got an adequate amount of insurance to cover the reinstatement valuation of the building, so that if anything were to go wrong or there was a catastrophic incident, that you've got the appropriate cover in place. And another really imperative point as to why it's important to maintain and look after your building is to have regular communication with the other owners. I know that that is very difficult in today's like just modern life and where we are. People, don't necessarily always want to engage with other owners. They don't really understand what their responsibilities are. But it is very important that as co-owners within a building, whether you have a factor or not, that you are in some form of regular communication with each other and you know how to contact each other. So as owners, what are you responsible for? In broad terms, you're responsible for repairs and replacements in the common areas of the building. You're responsible for cleaning, for painting, other routine works, things like gutter cleaning. You're responsible for gardening. If there's a garden and it's in common ownership, then there's a responsibility to maintain that. All the aspects of the day-to-day running of the building, reinstatement of most of the tenement building itself, should there be any issues, and also the installation of insulation. A lot of people think that insulation is a private cost to bear, but in the Tenements Act, it's quite clear that it is a maintenance responsibility that all owners are responsible for. So your title deeds are very, very important. If you don't have a copy of your title deeds, we would really encourage you to go onto Registers of Scotland website and pay the fee, which is I think about £3.60 in total, to buy a copy of your title deeds, so that you've got that copy, you can read over it, and that you understand what parts of the building are commonly owned and what your responsibilities are for maintaining common areas. Your title deed may also classify which elements are considered to be individual or mutual responsibilities, and they should also clarify how to allocate or split the costs of maintenance between owners for common repair work. So there are three types of repairs that you can get in tenement buildings. You will have individual repairs, which is generally repairs that an owner is responsible for, typically inside their flat. That will include things like internal walls, doors, windows, resealing baths or shower cubicles, and some of the drainage to sinks and things in kitchens and bathrooms. But generally speaking, anything that happens within the flat itself is usually an individual repair. Not always, but in most circumstances it is. Common repairs are, the main thing that we're going to be talking about today. So common repairs are repairs to parts of the building that all owners as a group are responsible for maintaining. And that includes things like the roof, external walls and foundations. You can also get mutual repairs, which can be repairs to parts of the building that are shared between some owners within the same building or between neighbouring buildings. So examples of that could be chimneys. It might be that there's a chimney stack on the roof, and it's a mutual responsibility because there's two blocks that share that chimney. It might be that the way that the drainage is being set up when the building was built, that one side of the building has got a responsibility for drainage on their side. So say you've got 8 flats in a block, it might be that, the 4 flats on the left side are responsible for drainage on their side. So the bills are split, 4 ways. And then it's the same for the other side. It might be that you share the drains with a neighbouring building. And it might also be that if you have main door properties or basement properties within your building, that they don't have access to the close and the common stair area. Therefore, that would just be the responsibility of the owners within the building who have access to the common stair area to pay for that. Now, title deeds aren't always perfect. Most of them were written a very, very long time ago. If you've owned your flat for a considerable period of time, you might find when you go on Registers of Scotland that your title deeds are actually on the old Sacine register and not on the new land register. So you may not have a great deal of information. Even if your title deeds are held on the land register, again, some of the terminology that's used may be unworkable. It may also be that the deeds are silent on certain issues that you need to have clarification on, and that's where the Tenement Scotland Act 2004 steps in. That includes what's called the Tenement Management Scheme, which is effectively a model set of deed of conditions and is a default position to use if your title deeds are silent or unworkable in certain areas. The tenement management scheme talks about scheme property, which is parts of the tenement that every owner should maintain. So that includes the ground on which the tenement is built upon, foundations and solum, external walls, mutual gable walls shared with adjoining buildings. It tells you how to come to agreements about maintenance, what counts as maintenance, and how costs are shared between owners. And the 2004 Act also clarified that the roof is a shared responsibility unless the title deeds say otherwise. Sometimes we get people that will use our inquiry service and they'll say, somebody's asking me for money for a roof repair, Jacqueline, but I'm on the ground floor, so this doesn't affect me. Surely that's the top floor flats that are responsible for that. Actually, unless the deeds specifically say it's the top floor that are responsible for the roof only, then it would be that all owners are responsible for the roof. Similarly, if your property has got a basement, it might be that that the ground floor is affected with rise and damp, or some other kind of issues that are happening below ground. The top floor may say, well, it's nothing to do with me, but actually it is. So it's just really important that you do know what your title deeds contain, what your areas of responsibility are, and how to use a tenement management scheme if your deeds don't cover something or they simply there's no mention of it. Generally speaking, when it comes to making decisions about repair work that's to scheme property as a common repair, you'll normally need a majority of owners to agree to it unless your titles say different. But in general circumstances, if there's 6 flats in the block, then you're looking to get a majority agreement, so 4 owners out of 6 agreeing to go ahead with work. Now, this is our diagram on organising common repairs. It's a 10-step process on how to go ahead and do that. It looks very kind of simplistic on screen, and I'm sure that you're all here today with your own experiences of organising common repairs or being somewhere within the process of this and, are thinking, Jacqueline, get real, there's absolutely no way you just follow these 10 steps and it all happens. I know that it's very, very, very difficult, problematic, stressful, emotional. Yeah, it just can take you on a roller coaster when you're trying to organise common repairs. But what we tend to focus on at Under One Roof is the importance of following proper procedures. So these kind of 10 steps are what are classed as the proper procedures. So whatever stage you're at with a common repair in your building or you're about to embark on it, we really want you to focus on making sure that you follow proper procedures so that if there are any issues at any stage of the process or, at the end of it, if you have to take any form of enforcement action or if you're seeking help from the council or another external organisation, that you're able to determine that you did actually follow proper procedures. So you did identify what the actual repair is. You did inform all of the owners about the repair. Let them know what the responsibility is, what the share split of cost is, and that you put it to a vote to make a decision on how to proceed. That you looked for contractors to get competitive quotes. You got final agreement from the owners to go ahead with a specific quote, that you got payment in advance, whether that was for a deposit or for the work in full. You signed a contract with the builder. You dealt with any issues that may have came up during the process of the work being completed, and that when the work is completed, that you have paid for that per the terms of the contract. Now, some important points to go over with you about that. As I say, proper procedures is something that we talk about regularly at Under One Roof. So what can you do to help you with following proper procedures? Well, make sure that you inform all owners about the repair issue and arrange some kind of meeting. It might be that you're here today, you've got a good relationship with all the owners in your building, or you might be here and you think, I've not got a clue who the other owners are, Jacqueline, everything's changed. Or, you're thinking, there's a couple of us who are in, are on good terms, we're in contact, but there's a few people who just ignore us or, always create some kind of, negative or like aggressive like response to things, and they just don't engage. It's really difficult for us to get together. What do we do? I think that regardless of the circumstances, every owner has got a share of the responsibility for the common areas. So as long as you can demonstrate that you have, you've made attempts to contact people, whether that's, you can show text messages, WhatsApp messages, emails, letters, etc., to prove that you have actually tried to inform them about what's going on. That will help you to follow proper procedures. Ideally, we would like you to arrange a meeting to discuss whatever the repair issues are, or if there's one big piece of work, that might be something that you can do in person. It might be, on some kind of video call like Teams, Zoom, or WhatsApp, whatever video call, whatever it may be, if you can't get together in person. Make sure that everything is recorded in writing. So anything that you're talking about in person or via technology, that somebody is taking down I guess the minutes of the meeting, or just the points that were discussed, and what decision people came to. It is important to do that because an owner can appeal to the land tribunal against decisions that have been made if proper procedures have not been followed. So it is really important to follow proper procedures, to minute everything, and make sure that you're informing everybody in the building, regardless of whether it's, a good, bad, or ugly relationship. Sometimes it can be difficult to actually find out who the other owners are. In days gone by, we would have known who all of the owners are in the building. But, things change as people move on, or, there's inherited property, or properties that are bought for investment purposes only. And it's very difficult if you need to get a decision for whether, that's a kind of a minor piece of maintenance work, or it's a large scale project, or it's just I need you to pay your share of the stair cleaning or the gardening. Then you need to know that there's support available to help you trace owners and landlords. So you can look on Registers of Scotland to get the title deeds. You would obviously have to pay for the title deeds for other properties in your building, or a specific property if it's just one, but that will give you the owner or the owner's name and address address at the time of purchase, which you could obviously use as a way to try and contact people. If a property is rented out, you can use the landlord registration website that's set up by the government. All landlords have got to be registered as landlords. So you'll be able to search for the property and either get the landlord's name and their contact details directly, or if they're working with the letting agent, you'll get the letting agent's contact details. If you're really stuck and you think somebody has not lived in this place for a very long time, I had somebody contact me a couple of weeks ago about a flat in their building that had been empty for over 20 years. And, they urgently needed to get in contact with the owner about a significant roof repair. What did they do? Most councils have got an empty homes officer, but the Scottish Empty Homes Partnership is a charity that exists to help people specifically with any empty homes issues. So if you're here today and you're thinking, I'm struggling to find out who owners are and how to get in contact with them, you can consider looking at one of these three things or all three of them, just as a way to try and trace people. Voting is really important. Voting on common repairs is a really important procedure and part of the whole process. Every flat is entitled to one vote. If the flat is jointly owned, then it's one owner that is making the vote on behalf of both. Unless the titles say otherwise, it's normally a majority decision that's required to progress with maintenance work, and it's binding on all owners. And a tied decision is not a majority decision. So if you had 4 out of 8, 3 out of 6, 2 out of 4, etc., then you would be looking to go back to the drawing board and try and see how you can change things around in any way with the communication that you put out there to really highlight and reiterate what the common responsibility is, and try to get another vote underway to hopefully secure your majority. Now, it's not all fun and games when it comes to organising common repairs. Sometimes people really do get stuck, and it is serious, and it can be really emotional and stressful. So we need to know what our options are when it comes to enforcing repairs. And there are a few options that you can look at depending on the situation within your specific building. But I think it's really important to talk about enforcement action and what is available. We see a lot of people who, come to us through our inquiry service who are simply at the end of their tether. Repairs taken over their whole life. It feels like their full-time job. They're not getting any downtime, and they're really, really, really struggling to get people to engage with them. They are struggling to get people to pay their share, and they don't know what to do. Not everybody has an appetite for enforcement, and I completely understand that. But once you take things so far, you can demonstrate that you've followed all of the proper procedures. You've got all of the contact details for the owners in your building, etc. You do have to look at enforcement. Now, there's several things that you can look at in the enforcement arena. The first one is the duty to maintain. That's a powerful legal protection for parts of the building that provide support and shelter. So things like roofs. All owners have got a legal duty to maintain, and you can enforce that. We've got information on our website about that, and how you can enforce the duty to maintain. We've got a customizable template letter that you can download, change to reflect the circumstances that are going on in your building, and send that out to the owners. Sometimes you need to go ahead with emergency repairs. We've got information on the website as to what the definition of emergency is, so you can check that to make sure that you meet that criteria and go ahead with a repair on an emergency basis. It may be that you need to consider lodging a notice of potential liability with Registers of Scotland on the title deed for the property. You normally need a solicitor to do this, but you can call Registers of Scotland, and what that notice does is it sits on the title deed, so that if an owner is considering selling their property, or you suddenly see the for sale sign is just up, or you see it online. If you've got a majority agreement in place to go ahead with work and the person selling, whether they've agreed to it or they've not engaged with you at all, a notice of potential liability will protect your majority agreement, and that if the property is sold during the repairs process, then you can the notice will sit on the title deed and alert the selling solicitor that there would need to be funds held back to pay for that when the property is sold. You can get help from your council. Most councils have got missing share schemes, work notices, and they can enforce repairing standard legislation that landlords have to comply with about keeping common areas in a good standard of repair. And there are legal options that you can use if you've gone through absolutely everything. You're like, Jacqueline, I've exhausted all avenues here. I've got nothing else to do. Then your option would be legal action. If you're kind of floundering on a repair and each individual share is under the £5,000 threshold, then you can use a simple procedure claims action at the Sheriff Court. This replaced the small claims court, and it's a DIY process that you don't need a solicitor for. You have to pay a fee, and you fill out an application form, and then the court can then take on the case. We've got lots of information on our website about how you do that. If it's over £5,000, if it's a major repair that's required, say, you're re-roofing it, and you're building and it's a significant amount of money, then you would be looking at using the ordinary clause action, and that will require a solicitor, so you would have legal fees on top of that. But there are legal avenues available to explore if you're at the end of your tether, you just cannot get anywhere, and you have demonstrated that you followed all of your proper procedures, then legal action would be the way to go. Owners associations are something that we talk a lot about at Under One Roof, and we will continue to do so. The Scottish Government are considering proposals from the Scottish Law Commission to make owners associations mandatory. So that is likely to come in with or a decision be made on that. They're looking at a draft kind of bill proposal at the moment. So that could be, I think it's tabled for spring next year. So it is something to be aware of. At the moment, an owners association is a formal agreement between owners of a building. It's not defined by any legislation at all, and it's not recognised as a corporate body. But we would always encourage owners to form an owners association and to have a constitution, which is an agreed set of rules and procedures for how your tenement building runs. Who is going to be responsible for roles within that association, so a chairperson, a secretary, a treasurer, how it will set out how you communicate with each other, how you make decisions, and how you plan for repairs and maintenance, and what your payment arrangements are. You can also get, when you form your association, you can open a non-interest bearing maintenance bank account, so that each owner can pay funds into on a regular basis. So it's something to consider if you don't have an owners association formed already. It can help you with communicating with owners, making decisions, and having a better arrangement in place for payments. So as I say, it is going to be a mandatory requirement once the Scottish Government considers this bill proposal. So it is a good idea to start thinking about that now and potentially get ahead of the game before it becomes a legal requirement. Advantages of owners association: it can make speedier and better decisions, gives leadership to the repairs process, and encourages active participation, and provides a single source of contact and better communication amongst owners. Property factors. We get a lot of inquiries through our inquiry service about factors, how to work with them, what they're actually responsible for, why can't they do things and just pay for it. So I think it's important to set out that factors are employed by owners to manage the common parts of the building. They don't own the common parts of the building, it's the owners who do that, and they are there to manage the building on behalf of the owners. They're governed by the Property Factors Act 2011. Factors have got to be registered on the public register of property factors. It's run by the Scottish Government. They have got to comply with the Code of Conduct that was introduced in 2011 with the Property Factors Act. And it's the first tier tribunal at the Housing and Property Chamber that's the entry point to the legal system in Scotland for issues with property factors. They're responsible for resolving problems where there's been a breach of service provision to owners by the factor. Then you would use the first tier tribunal to try and resolve that. Now, the code of conduct is really important when you're working with a property factor. You must understand what the code of conduct says so that you know that your factor is working in the right way. Often we get a lot of complaints about how the factors handled the situation or what they haven't done. We always say to people, have a look at the written statement of service agreement that was sent out to you by the factor. That's the contract between you both. And that written statement of service agreement has got to set out the factor's authority to act, the services that they provide, how they'll communicate and consult with owners, what their financial and charging arrangements are, any declarations of interest with your specific building, and how to end the arrangement. So it's a good idea to know what the written statement of service says, as well as the wider code of conduct, so that if things do go wrong or you're not happy with how they've managed a situation, that you can check against both those documents to see if there's been any breaches of the service agreement or of the code itself. The wider code covers more about communication and consultation, financial obligations and debt recovery procedures, common insurance, repairs and maintenance, and complaints resolution. So it is important, if you do have any issues with your factor and you are thinking about making a formal complaint using their complaints procedure, that you read over the written statement of services and the code of conduct to see how they have or have not complied with it. And I think it's just also important that, you might be here today and think, well, we've got a pretty good relationship with the factor. They're okay on some things, not so great on others, but I don't actually really understand what it is specifically that they are there to do, or I don't feel that they are doing everything that I think that they should be doing. Then have a look at the written statement and have a look at the code of conduct to see what they're telling you contractually that they will do for your building and what they're overall responsible for legally, so that you can, better understand whether what your requirements are within that bracket, or if they're out with it. So it's a lot to kind of get started with common repairs. There's a lot involved in it, and I don't say that lightly or flippantly at all. I really do understand how complex it can be. So where do we kind of I guess, round this up on, how do we get started with this process? In very kind of simple terms, we would always encourage owners to compile a list of all the owners' contact details and circulate that amongst the owners. As I say, you can use things like the landlord registration website, your empty homes officer at the council, or the Scottish Empty Homes Partnership. Or things like Registers of Scotland, if you are struggling to find who the owners are or to get contact details for them. We would urge you to consider establishing an owners association. It is a very good vehicle, and we've seen a lot of success that owners have had in making headway with work and just kind of getting a general maintenance plan together for the building once they've formed an association. And we we would like you to try and get ahead of that before it becomes a legal requirement. You want to obviously check that all of your co-owners have got the appropriate buildings insurance in place. Um, when we talked about at the beginning of the presentation about buying a copy of your title deeds from Registers of Scotland, the deed should normally state on them what type of building insurance that you need to have. It may state that you need to have a common or a block insurance policy, which is one policy that all owners pay a share of, or it may state that you have that an individual policy is required, or it may be silent, meaning that owners have got a choice as to what type of building insurance they want to have. The main thing is though is that owners must have insurance. It is a legal requirement. It will be a mortgage requirement if you have a mortgage on your property as well. So you must have buildings insurance in place. If you've owned your property for 5 or more years and you think, gosh, I've got absolutely no idea what the policy value is like for reinstatement, or we've never really even thought about that as a group of owners, then I would urge you to consider having an insurance reinstatement valuation survey carried out. It wouldn't be the first time that we've had people get in contact with us and say, such and such has happened, but it turns out that the original valuation survey was like £20,000, and obviously the building is worth a lot more than that now. It does it doesn't cover it. There's a shortfall. We want to make sure that owners have got an appropriate level of cover in place. They say there's no such thing as being overinsured, but you definitely don't want to be underinsured. So if you're not sure what the insurance situation is amongst the co-owners, have a look at the title deeds, know what type of insurance that you have, and then as you're compiling all of the owners' contact details, names, etc., that you're also asking them to provide proof of their building insurance. They can redact out any kind of personal sensitive information, but the owner should have sight of all of the policies so that if something were to go wrong, then there's some kind of comfort in knowing that there is insurance in place for all of the owners, so that you can move ahead with reinstatement work. Again, if you've owned your property for a considerable amount of time, 5 or more years at a minimum, if you've never had a professional building survey carried out by an RICS accredited building surveyor, or you're simply, you're like, Jacqueline, I've got absolutely no idea what's going on with the building. It's, how am I to know the ins and outs of it? Then we would encourage you to think about having a building survey carried out. It's something that all of the owners would need to make a decision on because they would be required to pay their share of it. But a building survey and condition report is a really important document because it'll set out kind of like in a traffic light way, red, amber and green, what you have to focus on urgently, and what you can plan for further down the line. But certainly if you don't know the condition of the building, it is worthwhile considering approaching the owners to have a building survey carried out. In lieu of that, it's easy enough for people, however able-bodied you are, to do inspections of the common areas of your building. It might just be as simple as looking at the building from the street and checking, what do the window surrounds look like? Is there any loose paving stones or railings as you get up to the common door? What's the condition of the main door? Does the door entry system work? Is the lock, a bit shaky, or is it secure? What's the condition of the stairs like? The walls, is there any sign of dampness or peeling paint? Do the downpipes look like they're in kind of good condition, or is it time to consider getting them painted? Is there foliage grown out of the gutter? Do you need to get that cleaned out? What do you need to do? So you can have a look at things yourself and try and put a wee list together and chat to the other owners about it. We would like you to clean your gutters and get the roof checked on an annual basis. It's once you kind of know where you are with doing an inspection yourself and having the gutter and the roof maintained annually, you can prepare a planned maintenance schedule to know, okay, every month we've got a stair cleaner coming in or we've got a gardener coming in. Once a year, the guys will be here to clean the gutters and check the roof. We'll schedule in to have all the external windows repainted or the downpipes repainted, things like that. Um, we talked about owners associations and having a joint maintenance account, which is a really good idea so that you can start saving for future repairs. And your joint maintenance account is something that you can just pay into for all your regular kind of work, like your stair cleaning, your gardening, gutter cleaning, etc. So that you've got a fund there, so it's not, you feel like you're just constantly going cap in hand to all of the owners, or you're thinking, gosh, here's this person sending me a text asking for another £100 or £20 or whatever it may be. Once you've got that maintenance account, then it's something that you can make regular payments into. If your building's factored, we want you to liaise closely with your factor, make sure that they're carrying out site visits, that you've got regular meetings with them, that they know what the owners are looking for when it comes to the building being maintained, and that you're clear on what the contents of the written statement is, as well as a wider code of conduct to know that the factor is working in the owner's best interest. If you don't have a factor and your building is self-factored, you might want to consider how you deal with common repairs. Is it always the same person that deals with it? Would an owners association be a good idea to form to kind of help you guys take the pressure off one person or one couple or a couple of owners who're always doing things? Some local authorities have authorised the use of the Novaville Shared Repairs app. I'm not 100% that Argyll and Bute have got there yet, but it's an app that's available that helps owners to coordinate and pay for shared repairs, common repairs within their building. But if you're here today and you're thinking we don't have a factor, sometimes it's just a realization is where the penny drops. Okay, we're self-factored in this building. There's nobody, there's no white knight coming in to on the horse to be the last man that frees all and gets all this work done. It's down to us to do it. We all own a share of the building. So we have to get ourselves organized to be able to manage this. So how can we help you under one roof? Well, we have literally got hundreds of informative articles on our website. The original tenement handbook that our founders, John Gilbert and Annie Flint, wrote in the early 90s has been updated and on our website. The book is effectively the contents of our website. We've got lots of up-to-date articles on there, as well as legislation and regulations have changed. We've got lots of architects, intricate drawings. John Gilbert, one of our founders, is an architect. So we've got lots on the technical side of the website. If you think, gosh, my neighbour is asking me for money for, a gutter repair or something to do with the chimney, I've got absolutely no idea what that is. 9 times out of 10, you can go onto our website and you can put, the gutter or chimney or downpipe or damp into the search function on our website, and you'll get a couple of articles that will go through things in a lot of detail with you about what's required maintenance wise, replacement wise, and just the intricacies of the different types of repairs. So do have a look at our website. We've also got our inquiry service, the Ask an Expert service. So when you're on the main page of the website, you'll see the button at the top to ask an expert. You can click on that. You can put in your details and the nature of your inquiry, and it'll come to me and my colleague Stephen, and one of us will get back to you within a few days or so with a response. Sometimes people use that when they're a bit overwhelmed looking at the website as a whole, or they maybe don't have the time to look up specific things, or it might be, that there's a sensitive issue that they're dealing with. For anything kind of tenement management and maintenance related, the inquiry service is a really good one to use. So that's the end of the presentation. I will move over back into the live area to take questions now. If you just, as I say, you'll get a copy of the presentation, the slides and everything, the recording of today's event in your inbox within the week. But my email address is on screen if you want to take a quick note about that. If there was anything that you wanted to contact me about directly, out with the Q&A that we're going to do today, or once you've maybe had a look at things, if something comes to mind, you give it a wee bit of thought as we move into the second half of the week and the weekend. I'm more than happy for you to get in touch with me. So let me stop sharing the screen. Hi Claire, see you back in. That's great. Okay. So let's have a look. Where are we? We're at 12:45. Okay. Let's have a look at the Q&A and see where we are. Okay, so I've got a question in from from Isabel voting. Live in a tenement where there are 10 flats, belong to an investment company, 3 are privately owned, but she's one of the owners. Investment company are majority owners. Am I right in thinking that us, the 3 private owners, cannot have a vote on any decisions? No, Isabel, you're still entitled to have a vote. Whether they're the majority owner or not, that doesn't give them carte blanche just to go ahead with any work that they want to do without consulting you and the other 2 privately owned properties in your building. Legally, they still have to give you the opportunity to vote. They still have to inform you as to what's going on, or it might be that you take a repairing issue to them and ask them to vote on it. But every owner is entitled to one vote, whether they're a majority owner or not. Everybody still has to vote. Hopefully that answers your question. Oh, sorry, 10 flats in total, 7 belong to the investment company. Okay, no, I see what you mean. All right, as I say, you and the other 2 owners, private owners, are still entitled to vote. Even if you always vote against something, and they go ahead as the majority, or vice versa, you're still entitled to a vote. Great. Okay, so I've got Rob just put in, can a factor chase up on collecting money for work from a flat, and if need be, take legal action? Yes, Rob, they can. So if it's been agreed for a piece of work to go ahead, then the factor would normally advise all of the owners about the work, seek their agreement to go ahead with it, and confirm what the payment amount and arrangements are. If an owner doesn't pay on time, it can obviously hold up a piece of work going ahead, depending on what that work is. But it will be set out in the factors written statement of services agreement, as well as in the wider code of conduct, what the arrangements are for chasing up payments, and what the debt recovery procedures are. Sometimes they can spread debt among other owners if they cannot get any money at all from a particular owner, but normally that's when it's really far down the line. But if it's a piece of work that's been agreed to, there's a majority agreement in place, then yes, they can follow their policies and procedures to recoup the funds from an owner who's not paying. Let me just check in the hi Fiona, I see you've put in the chat you've got a notice of potential liability question. I don't know if you want to just put that in the Q&A. The way that this is set up, we don't have the function for everybody to just kind of jump in, turning their mic on and asking a question. But yeah, I'm certainly happy to answer any questions about notice of potential liability. Claire, I don't know if this is a good time to maybe just bring you in. We were chatting off screen about the Helensburgh cars scheme, weren't we? And just saying that it's due to come to an end next year. Is that right?
Yeah, in March 2026.
Okay.
So all of the funding has been allocated at present. However, there may, as projects sort of come to a close, there may be some additional funding at the end which isn't spent if we do have underspend on some of the projects. But we are also happy to help people set up owners associations, and we can work with a housing team in order to do that. And also there is other funding within the council that might be available for common repairs should owners need that moving forward.
Okay, great. That's fantastic. Thank you. Rob has just asked, do you just need a majority of flats to agree to appoint a factor? Rob, it depends on what your title deeds state. I would have a look at them. I think the norm is normally for a majority of owners to agree, but some title deeds can have quite specific requirements on how many owners need to agree. It may not be a majority, it may be more. So have a look at your title deeds, get a copy from Registers of Scotland if you don't have one to hand. And yeah, and you can see what the deeds state. We have got a page on property factors on our website, and that talks you through the process of appointing a factor, and the Scottish Government have also got information on their website about appointing and dismissing factors. So it is a good idea to have a look around online for the information from our site and also on the Scottish Government's webpage. But yeah, if you're looking to appoint a factor, the first protocol is to have a look at your deeds and to see what they say. Fiona, I know you're asking where the Q&A is to type a question, where it's next to where the chat function is that you're typing in at the moment. But if you want to ask your question about notice of potential liabilities in the chat function, then I'm happy to answer it from there. Otherwise, you can send me an email directly, and I'll put my email address in here. Great. Okie dokie. Let's see if something comes through for that. But otherwise, I think that we're kind of getting to we're at 12:52 and we're here for an hour, so hopefully we'll get that. If not, Fiona can contact me directly. But I hope that you found that useful today. As I said throughout the presentation, I know how complex this situation is and how difficult it can be when people are not engaging with you. But it is, I guess, important to understand what your obligations are as an owner, and to use the template letters that we've got available on our website when it's informing owners about repairs, or if you're looking to enforce the duty to maintain, customize those template letters to suit the circumstances, and then send them off, and see if that helps you with getting engagement from people or getting responses from people about certain situations. It is very important to follow those proper procedures, but there is help available so that you can get to that stage. If I guess you're here, and where Rob was going with his questions about factors. If you don't have a factor appointed for your building and you are struggling with owner engagement, or just to kind of keep up with the maintenance of it, then do have a look at your title deeds and do consider whether appointing a factor would be a good idea for your building. Okay, so Fiona has put here notice of potential liability cost solicitor quoted £800, but form looks quite simple. As you mentioned, contacting Register Scotland, can we do it ourselves? Um, I believe that there are circumstances where people can lodge a notice of potential liability with the Registers of Scotland themselves, but the best people to speak to about that is Registers of Scotland directly, and they will be able to guide you through the process and to let you know if they will accept that. Because I think I'm from memory it might be around 70 or 80 pounds to lodge the notice. I could be wrong, but I think it is less than £100 to lodge the notice, but obviously you'll have solicitor fees on top of that to do the work for you. But speak to Registers of Scotland, their phone number is on is on their website. And they're normally pretty good at engaging with people and just letting them know what they will and won't accept, and the best way to go about it. Um, you can also look on the Law Society of Scotland website for solicitors in your area, just to try and shop around and see if you can get a better fee structure if you need to use a solicitor for that. Um, just check the Q&A. Kerry has asked, what are the options for tenants and owners when a majority vote cannot be obtained for common repairs when they are required? Okay, in that situation, you would be looking at the type of repair that is required, and considering whether it's a duty to maintain issue. So is it to a part of the building that provides support and shelter, or is it a simple maintenance obligation? And you would be looking to try and invoke the duty to maintain if it's an issue that comes under that category. It would be going back to the owners to write out to them to say, this is what your legal obligations are. You can use the simple procedure claims action at the Sheriff Court to enforce owners to comply with their maintenance duties. It's not just about recouping funds. You can ask the Sheriff to consider, an action, raising an action against owners to say that they've got to comply with it. And you can also speak to your local council as well. Depending on the nature of the work that's required, environmental health may be able to come out and make an assessment of the issue, and perhaps put a work notice or a work order on the building, means that owners have got an obligation to deal with that. It really just depends what the situation is, but there are options available to you. Um, Owners associations are right, they're not a corporate entity, or they're not a legal entity, and the owners association can't take legal action. It would be if you do have an owners association for your building and you do need to take legal action against an owner who's not paid their share. Then each individual owner would need to make an application. If you were using the simple procedure, um, they would need to make an application to the Sheriff Court, and they can reference the Owners Association as their contact for it, and it can be done that way. We recently updated that on our website, so you can have a look at that option. I think it's on the property factors page, about taking legal action and what the options are. But it can't be as an owners association. It would need to be on an individual basis, and obviously you can just have one form that can be copied for each owner. Okay, I can see that Paul is typing. I'm just conscious of time here. We've only got a couple of minutes left, but let's just see. Is kind of like class as a window individually responsible or part of the is a roof light, sorry, class as a window individual responsibility or as part of the roof communal. That's a bit of a grey area in tenement law, Paul, where a skylight or like a dormer, something like that, if they're classed as being a common responsibility or if they're individual, I would suggest that you check your title deeds to see what they specify about that. If not, we've got a page on our website on skylights, and that can kind of direct you for some more information there. But have a look there. All right, that's us pretty much at the top of the hour. I see some people have dropped off. They've obviously got to get back to work or whatever they're doing. So I think this is probably a good time just to bring this to a close today. Thank you so much, everybody, for being here. I really appreciate your time, for listening to me, and the questions that you've asked. Do consider, where the car scheme is at the moment. If you do need to, explore that option for repairs in your building, if you're in the designated area, get in touch with Claire and reach out to her, just in case. There's some availability funding wise for you, and Claire's put her email address in the chat. As I say, you'll get a copy of the recording and the slides sent out to you within the next week. Please do keep in touch with us and let us know if you've got any other inquiries that we can help you with. And thank you so much for being here today. Enjoy the rest of your day. Thanks a lot. Thanks, Claire.
Thank you. Bye bye.
Bye bye. Bye.